Hey guys, just wanted to take some time today. We are going to be talking about Addenda, the most popular addenda on the Texas Association of Realtors contracts, Texas Real Estate Commission contracts, and a couple of addenda we'll be talking about today. We're going to talk about the addenda for sale of other property by buyer. We're going to talk about the reservation of oil, gas, and other minerals. We're going to talk about the addendum for backup contract, and we'll finish up with the buyer's walkthrough and acceptance form. So that's what we're looking at discussing today. Let me go ahead and get some of these forms up on the screen for you, and we'll start with the addendum for sale of other property by buyer. This will be the addenda that you're going to use when you've got a buyer that's got to sell one property to be able to purchase another property. It may be a move-up buyer. They're selling a smaller place, maybe getting a bigger place. It could be an empty nester. Maybe they're selling the big house and got to get the smaller home. Or it could be a lateral move. Doesn't really matter. But addendum for sale of other property by buyer. They cannot qualify keeping the current home that they own. So they're going to go ahead and have to sell one property. The sale is going to be contingent upon them selling that property in order to be able to qualify for the next property. So what we've got first, addendum for sale of other property by buyer, we put the address here of the property that they are purchasing. So this is the property that they want to purchase is our first blank. The next thing we've got, contract is contingent upon buyer's receipt of the proceeds from sale of the buyer's property at, this is where you will put their address of the property that they need to sell. And then underneath it, guys, we're going to need to put a date there. The contingency. They are going to get the receipt of the proceeds. So it's going to have to close and fund by the date that you put down here. So it does go on to say if the contingency isn't satisfied or waived. So if they don't sell the property or waive the contingency, we'll look at how they do that in just a minute. The contract will terminate automatically and the earnest money will be refunded to buyer. And you can see that here at the end of A. Obviously, the date that you're putting here, the next paragraph tells us that closing date should not be later than the closing date in the contract. So what would you put in A? Well, if I've got a contract closing in 45 days, let's say, make sure you put a date in paragraph A that's less than whatever date you picked for closing. So that's what they're talking about there. Now, here's the kicker. Letter B. If the seller does accept a written offer. So you're the primary contract with your buyer, but your buyer's got to sell that property first. You are the primary contract. The seller can continue to market the property. They accept another offer. They do that with the backup addendum. Once they've accepted that second offer, it is executed, earnest money is deposited, option fee money is given, if any, all of those things are going on, then at that point in time, the seller shall notify that first buyer, hey, it is time to put up or shut up. I've got someone else that is ready to purchase my property. Typically, what we're doing in B, in the blank here, is we are putting the number of days there. So typically, we're putting 3 days here. So the buyer's got what? 3 days, if that's what we fill in there, to make a decision about either purchasing the property and or getting out of the way. Now, if they do decide to stay on contract, they are going to have to waive the contingency. How are they going to do that? Letter C will define that. Buyer may waive the contingency only by notifying seller of the waiver, and here's the most important part, depositing additional monies. More money is what I like to say with the escrow agent as additional earnest money, okay? So you had an original amount of earnest money. Now you're asking for more earnest money. People ask me, what should we put in there? If you're a listing agent, you probably want to see the same deposit as the original earnest money. If you're a buyer's agent, you want to probably see something less. Obviously, that is going to be left to the negotiations of the parties and what they agree to. Please, please, please do not leave this blank. That is going to be some heartache if that should happen. So anyway, guys, the other thing that we need to be aware of on this addenda for sale of other property by buyer, take a look at letter E. Time is of the essence, okay? So that is something that we've got to also be aware of. Going back to D, though, if the buyer does waive the contingency, they put up those additional funds, what will happen then is if they don't close because they didn't get those funds, then obviously the default paragraph will kick in. That's simply going to mean that the seller can go after the buyer for specific performance, maybe such other relief as may be provided by law, get sued for damages, or they could take the earnest money as liquidated damages, which that should probably be a sizable amount of money because in paragraph C that you're looking at here, they deposited additional earnest money. In a nutshell, guys, that is the addendum for sale of other property by buyer. Now, one of the things that I'm doing in this training is I'm giving you the follow-up forms, okay? Follow-up forms, what are you talking about, Tony? Well, you've got this addendum for sale of other property by buyer. Should the buyer back out at this point in time, another contract comes in, all bets are off at that point. But what will happen is you will have to be notified in writing by your seller. So if we take a look at the next form, this is a TAR form, and it's called Notices Regarding Contingency under the Addendum for Sale of Other Property by Buyer. So this is seller buyer information concerning the property at 123 Anywhere Street. Seller is notifying the buyer to remove the contingency. So you've got the primary contract. It's got that addendum for sale of other property by buyer. The seller has now received a second offer. That's been executed. That's got the backup addendum on it. Now the seller is, the listing agent is going to fill out this form, have the seller sign it. They will then present this form to the first buyer, notifying them, again, it's time to put up or shut up. And then it's up to the first buyer to figure out what they're doing. So anyway, guys, this is the addendum for sale of other property by buyer. If you take a look, that is TAR 1908, the initial addendum that we use. If you're using the follow-up addendum, that is going to be TAR 1912. The other thing that you see on this form, guys, is written notice from the buyer saying what they are doing. So the first one is they're waiving the contingency, putting in that extra earnest money with the title company. Or number two, you know what, we don't waive it, contract's terminated, we're out, give us our earnest money back and you're good to go. So anyway, that was TAR 1908, TAR 1912 is those two forms that are related there. If we go on to the next document, guys, this won't affect El Paso, but this is in effect in the DFW area. This is the addendum for reservation of oil, gas, and other minerals. So if you've got a seller that is reserving all or a portion of the mineral rights, if any, and the only way to know for sure if you have mineral rights is to hire an oil and gas attorney or hire a landman to do the research for you. Please, please note the title company, the title policy does not cover anything that has to do with mineral rights. So if the seller believes they've got mineral rights, they're getting it checked out, and they want to reserve them, this is the form that they would use. Addendum for reservation of oil, gas, and other minerals. And so you put the property address up at the top. Letter B, seller, B1, seller reserves all of the mineral estate owned by the seller. B2, seller reserves an undivided 1/4 interest, 1/8 interest, 33% interest, whatever it might be in the mineral estate owned by seller. Okay, seller, letter C, seller does or does not reserve any implied rights of ingress or egress of the surface rights. You got to remember, you've got the mineral rights underneath. But if you have a oil well on the property, maybe it's a farm ranch, a large parcel, you're going to have access maybe to an oil well in the backyard. Someone's got to have a road or something of that nature on there. So anyway, take a look at that. The one thing we do need to be aware of, if you do not add this addendum to the standard tract contract, what happens is the mineral rights automatically convey, okay, if any. And again, you've got to get a landman or an attorney that is familiar with oil and gas leases to check that out for you. Get with me. I can definitely point you in the right direction there here in the DFW area. The other thing that I found, guys, doing a little bit of research, there is a great form from TAR, which basically is just an information form about mineral clauses in contract forms. And it talks about mineral rights. They give you a little bit of history, who owns the minerals, the fact that the minerals may have been severed. It does talk about this addendum if you do want to reserve the rights. And again, if you're curious about what's going on, a lot of people don't know this, but it's the Railroad Commission of Texas that covers all of the drilling and oil and mineral rights in the state. So anyway, this would be a great form to just pick up and read. If you're looking for the numbers, guys, the Reservation of Mineral Rights form is TAR 1905. Highlighted it there on the screen. This information about mineral clauses, which you might just want to read through, it's a great document, is TAR 2509. And again, this is something that we would have people sign, probably especially our sellers. Good idea for our buyers to sign this as well. But I just wanted to bring up these two forms regarding mineral rights. The next thing we look up, guys, is the backup contract, okay? We talked earlier about the example of the contingency offer, and you get on contract, you're the backup offer. You got to wait 3 days, see if that first buyer goes away or not. But if they don't go away, you can still stay as a backup. Obviously, your backup buyer is going to be praying every day that that first buyer doesn't qualify or something happens and they back out. But basically, guys, one of the biggest challenges, one of the biggest misnomers that I see when it comes to the backup contract, agents will tell me they have a backup. I will immediately ask them, have you deposited the earnest money? Was there any option money due? And has that option fee been paid? And people say, no, we're just a backup. Well, I've got to tell you, if you didn't deposit the earnest money, if you didn't give the option fee, guess what? Someone's in default. Because if you are a backup contract and it's signed and it's executed, notification has been given to everybody, guess what, guys? You must deposit that earnest money to have a valid contract. So please make sure that you are following through and taking care of that. So, addendum for backup contract. What are we doing here? Well, it talks about in paragraph A that the backup contract is contingent upon the termination of a first contract dated, and you've got a blank here. You're going to have to get that date, the effective date of the primary contract, from the listing agent. So, contact the listing agent, find out the effective date of that first contract, and that's what you're going to fill out here in this blank, okay? The other thing is, guys, take a look at the last sentence. Neither party is required to perform under the backup while it's contingent upon termination of the first. So while you're the backup, do not do inspections. Okay, still want to go into loan app, make sure your financing and everything's in order, but you don't perform all the other steps of the contract while you are the backup. Now, letter B, what are we going to put in here? Basically, what you're going to do is, the way I like to say it, is your buyer is going to tell you what their tolerance for pain is. How long will they wait? Many times, the date I see in here is the executed date on that primary contract. They say, you know what, we'll stick around. Let's see if they close or not the entire time frame. You can put a different date in here, obviously. So take a look at that. And basically, the question becomes on letter B, Mr. or Mrs. Homebuyer, how long would you like to wait? Okay. The other thing that happens, guys, letter C, someone does an amendment on the primary contract. They're letting you know that is not a termination of the first contract. Your backup buyer might get all excited and say, ooh, they're changing something. That's a termination. TREC is being very clear here, letting us know that that amendment or modification of the first contract does not terminate the first contract. Letter D is one that should set your buyer's mind at ease a little bit. And what does paragraph D say? Well, basically what you're looking at here, guys, is the buyer pays an option period, okay? They're the backup. Well, the entire time that they are the backup, they have that unrestricted right to terminate, okay? I don't know if you guys caught that. While they are the backup, if they paid for an unrestricted right to terminate, the entire time they're a backup, they have that unrestricted right to terminate and can opt out of the contract. Now, whenever you become the primary, which is what we're hoping will happen, everybody's hoping to become that primary. What will happen at that point in time, guys, is when you're notified that you're the primary, you will have then an amended effective date. So you had that first effective date when everybody came into agreement and you were a backup. But now when you become the primary, you now have an amended effective date. Just as an example, if you had 10 days of option period, once you become the amended effective date, we start counting those 10 days off. When you get that amended effective date, that is when everybody really starts performing on the contract, because now you're in a primary position. The other thing to take note of, guys, again, letter E here, pardon me, time is of the essence. So what you're looking at here, guys, is the addendum for backup contract. This is going to be TAR 1909. I will have a list of the forms and the numbers in the notes on the video when we get this uploaded. The next thing you've got, guys, and again, this ties in with the backup addendum. This is the notice that a seller would give a buyer, letting them know they are no longer the backup. So this removes the contingency under addendum for backup. So this is from seller to buyer concerning the property at 123 Anywhere Street. And look at number 1. The first contract is terminated. Contract with the buyer is no longer subject to the contingency, and the effective date of the contract is amended to, this is the date that you get notification. So if you were on backup, you're representing a buyer on backup, the first contract goes away. Then at this point in time, you would receive this notice. It would be dated today. Boom, today is the amended effective date. Now, let me go back and cover one point. If you're the listing agent, do not give this notice to the backup buyer that they're the primary until you have a fully signed release of earnest money letter, signed by both the buyer and the seller, and everybody's figured out what's going on with earnest money. Everybody's released themselves of all claims. Once that is done and that is clear, we then move on and we give the backup buyer this notice, letting them know they are now the primary. The last thing we want to do is sell the same house twice. We do not want to have 2 buyers on contract thinking that they're both on contract for the property. I don't feel like buying anybody any houses. I don't think you do either. And let's not use our E&O for issues such as that. But if you get into any conflicts or any questions like that, please give me a call and we can take a look at that issue. Now, the last thing that I want to take a look at, the very last addenda that I want to look at, is called the buyer walkthrough and acceptance form. This is a form, guys, that you should have filled out the day of a closing. We're all very familiar with new homes, and we're familiar with the fact that typically a builder's not going to let you go to closing until you've gone to walkthrough. Okay? Now, really different purposes on the new home. The builder wants to make sure that you understand what you're buying, that everybody's in agreement and condition. They talk about the punch list and the repairs that'll be done on down the road. which things will not be done on down the road. This form right here is really to take care of our buyers, okay? Make sure there's no confusion. Basically, guys, if you take a look at our 1 to 4 family resale contract, your buyer is supposed to get the property on the day of closing in the same condition, normal wear and tear accepted, as that when they got on contract, the day that they saw the property. So you've got a home with a swimming pool. Go do the walkthrough before closing. Make sure the pump is working. What happens if the pump hasn't been working for the last 3 or 4 days? Your buyers don't do a walkthrough before closing. We don't instruct them to do it. They go to closing, they get their keys, they show up that evening, and the pool is green because the pump has not been working. There's going to be some heartache there. So always make sure that you're doing a walkthrough before closing. I would tell you to do it the same day. I know agents that do it the day before. Many things can happen overnight, is kind of my opinion. And there's no guarantees that nothing won't happen during the day, but at least you're cutting that time frame as short as you can. So you got a closing at 3 o'clock, you know what? Meet out there at 11 o'clock, 12 o'clock, 1 o'clock. Make sure you've coordinated with the other agent, keys, make sure you have coordinated utilities being transferred over, all of those kinds of things, okay? But if we take a look at this, guys, basically it talks about the first paragraph, what I mentioned. They're going to get the property in present or required condition, ordinary wear and tear accepted. And it's got a great disclaimer here. Before closing, the buyer should verify the condition of the property meets the terms of the contract. That's not our responsibility, guys. It's the buyer responsibility. But we do, I believe, have a responsibility to remind them about this form and have them go look at the property before closing when they do have leverage. After closing, they've given their money, sellers have received their funds, sellers tend to distance themselves from any issues on a property. And then the next part, letter A, let's verify. Number 1, inspections were done. Buyer picked the inspectors. Number 2, buyer chose not to have the property inspected. If that was the case, let's make sure that we get that documented. This is one of the best cover your anatomy forms that we have, I believe, in the real estate industry in a transaction, a residential transaction. Before closing, buyer had a walkthrough, reviewed the property before closing, put the date here, guys, in this blank. I would tell you it's not a bad idea to put a time there. Timestamp it, okay? Or number 2, buyer was in a hurry and chose not to have a walkthrough. Oh, one other thought for you guys. A1, A2, B1, B2, I would have them initial next to the checkbox, okay? That's how critical I think this form is. Don't just do a checkbox. Get their initials next to the checkbox and make sure that you're covering your anatomy. Next thing, acceptance. Buyer accepts the property in its present condition. The last paragraph is very important also, and it's in bold even. Brokers have no knowledge of any defects in the property other than what has been disclosed in the seller disclosure notice or other written information the brokers may have provided. Brokers have no duty to inspect the property for unknown defects. It is the buyer's responsibility to have these inspections completed. So if you take a look, guys, this is going to be signed by the buyer, TAR 1925. Make sure you're utilizing this form before every closing that you're doing. Critical, critical form for us, guys. Anyway, what we're doing, guys, is basically this is just a couple of the addenda that we use, but probably the more popular addenda. I'm going to do a separate teaching on the temporary buyer and seller lease addenda. Happens if a buyer's moving in early, seller staying after. We'll take a look at that lease. It's got a couple of quirks in it we need to be aware of. And I'm also going to do a completely separate class on the appraisal addendum. And just a note on that, that's an addendum that talks about what happens and terminating the contract if the property comes in at some different sales prices. Important note, you cannot use the appraisal addendum on FHA or VA financing. It's really pretty much just for conventional. But anyway, guys, just wanted to go over some of those addenda. I just want to wish everybody a prosperous day and go out there and sell something, guys. Happy selling.